All right, we are live and there we go. Now we're recording.
Awesome.
Hello, everyone, and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we are here every Monday at 10 a.m. Pacific time, 1 p.m. Eastern time, and we go an hour in then to get to Mountain and Central. And we talk about all things related to trusts and probate and estates, and both from the perspective of your own personal finances, as well as people who are interested in working in that arena and helping people with their succession planning, with dealing with trust and estate matters, helping other people deal with trust and estate matters, and on all of the attendant things that go with that. So it's kind of a dual purpose that we're here for each Monday. And I am very pleased to introduce my guest today, Paul Hilton. So Paul is a military veteran, and after a career in the Marine Corps, right?
Absolutely, yes.
After retiring from the Marine Corps, Paul eventually went to law school and got involved in the trust and estates area of law here in California. He and his wife live down in the San Diego area, Rancho Cucamonga, I believe.
Well, we live in San Bernardino County, but we've been in San Diego for many years. Yes.
Yeah. And so I'm really pleased to bring Paul's expertise to you. We were talking, I believe it was last week or the week before, and he was telling me stories of some of the cases that he's been involved with, and we were actually swapping stories. But you know, as those of you who have seen my other shows know, my intention is to talk as little as possible when I have a guest, and really kind of give them the floor to share their thoughts about our topic with you. But first of all, Paul, welcome. Thanks for coming on Trust and Estates Weekly.
Thank you, Kevin. It's great to be here.
So tell me, just to get started, why did you end up getting involved in this particular area of law, as opposed to, say, corporate law, or, personal injury, or some other area of law? What drew you to this one?
Or criminal law or anything like that? Yeah, good question. And I still struggle with how that came about myself. So, like you said, I came into law later in life. I was in my 50s before I went to law school, and went to law school. I thought I was going to do personal injury or criminal. I thought I was going to go down that road. And in fact, when I was in my last year of law school and I was about to go to retire I was working for the Department of the Navy as a federal employee, been doing that for 12 years, and going to law school at night. And at the end of that, I was able to take a hiatus or something, as I was retiring, and I was able to get an internship in my last year of law school. And I went to an estate planning firm to do personal injury. That sounds a little strange. So this attorney had been working for many years. He had his solo practice for many, many years. And as he did estate plans, he did trusts and wills and things. That's what he did. But over the years, he had so many clients, and they got in car accidents, and they had slips and falls, and they would come to him with, how do I sue somebody? How do I get paid off for this? So I went to him as an intern just to help him with doing the demand letters, doing the things, the personal injury things. Mm-hmm. And so I spent quite a bit of time with that, but I became fascinated with the whole the estates and the probate code and all the things that were involved with estate planning and wills, trusts, estates, and probate.
Mhm.
That part of his business, it excited me, interested me more than the personal injury. So, graduated from law school, took the bar exam, passed the bar first time, California, in that was 2018. Licensed at the end of 2018, and in 2019 I went to another estate planning firm, and learned some of the systems, how to do it. There's 2 or 3 systems as an attorney that help you manage the clients, and then systems that help you do estate plans better, trusts and stuff. I learned those, and then I did a lot of pro bono work in probate court. Figured out how to get to the probate court in San Diego, how to get parking and how to do all those little things. And
no small task, by the way.
Exactly. So that's what got me into it. Yeah.
So then you mentioned a couple of things, and so being a lawyer, I think you can speak to these more precisely than I can. So when we talk about doing an estate plan, how does then a trust or a will, or how do those various things fit into an estate plan? And let me ask kind of a pre-question. Who should be and when should they be looking into doing an estate plan? So, a kid just getting out of college, does he need to worry about an estate plan? Or, who is that person, or that group, that couple, I guess, and when should they be concerned? And then what goes into that?
Good question. So we should always be planning our estate. You should be building an estate too. So I say should. I don't like to use the word should. Should is one of those words you ought to do, but you don't have to. So those are rough. But so, in the Marine Corps, when you were 18 years old, before you deployed, they made every Marine, we made every Marine you had to get a power of attorney and a will done before you deployed. And these young Marines are 18, 19 years old. They don't have anything, but it helped. There's so many things, assets that have to pass, bank accounts, cars, anything that's titled in your name. As a minimum, you need to have a will so that somebody, after you're gone, somebody can take title to that, and it doesn't just sit there, and you don't have to go to probate court potentially to see the judge. I just filed a probate petition last week. The hearing for that thing is in November. I filed it in June. The hearing, so probate really is slow. It's the judges here in San Diego are great. The probate court here is great, but it is so backed up. So you start with a will. If you're a young person, get a will, get your will done. Things will pass. But then the next thing, if you have any asset, any group of assets that your gross estate is over 166,000 in California, other state, the threshold's different in other states. But if you have a house, for instance, in California, you have a $166,000 estate. The only way that house passes to anybody else is through a probate petition. So what's the best? So you have a house or any estate asset, you want to put that in a trust. So we talk about things that I talked about a will just a minute ago, but we want to talk about things that pass without probate. If they're a small asset and you have a will, they can pass without probate. If it's a large asset and it potentially, the only way it really can get through probate without probate is to be in a trust. Assets in trust, for instance, and you'll hear this, revocable living trust a lot.
Mhm.
Assets that are named into a trust, they pass without probate, assuming you did them right, the attorney you worked with did them right. Now, there's other assets that pass without going through probate. Life insurance doesn't go through probate.
Okay.
Unless the beneficiary is a minor. Don't do that. Don't name the beneficiary as your 9-year-old son. You're going to have to, somebody's going to have to go to probate court and get a guardianship of the estate to get that money for your 9-year-old son that you decided to name in probate. All right, or in your life insurance. Another thing that passes without probate are most of those qualified retirement accounts, 401ks, IRAs, things like that. So you got to think about those types of assets, and so we talk a lot about revocable in estate planning. You hear people, that revocable trust, revocable living trust, all people, what is it? Well, a revocable trust just means that you can revoke it during your life. And anything you put in it, you can take out of it. Okay. Irrevocable trusts, you'll hear that term a lot. That's a different animal. Let's not talk about that. In general, you want that revocable trust. And think of a trust as a purse. Or a bucket. It's just a device, a legal device that you can put stuff into and instructions, so that when you pass or become incapacitated, whoever takes out those instructions tell him or her, the successor trustee, how to distribute the stuff that's in the bucket or in the purse. Mm-hmm. So that's one part of estate planning, that the trust. That's, so you want as much as you can to get as much stuff into a trust as you can, or some vehicle that does not require probate to pass on to somebody when you're gone.
So I'm sorry. Yeah. No, couple questions. You mentioned in California, there's a threshold of $166,000. So does that mean any asset below that amount, no matter what it is, can pass to an heir without probate? Or is it still only certain assets, like a life insurance policy to an adult or a qualified retirement account that passes?
Good question. Assets actually, if the gross estate, the combined gross estate is below 166,000, those pieces of the estate can pass through something, a small estate affidavit, essentially, where you can go and either show. This is why I said you have a will. So you go to that bank that has that money or has that asset, or a brokerage firm who has that asset in the name of the decedent. You bring the death certificate and the small estate affidavit, and you go, and the will, if you've got a will, that really helps. And you go to the bank and say, look, I'm named in the will. Here's the will. Here's the affidavit. This person is dead. Mm-hmm. This asset is fairly cheap, and I'm named in the will. It should pass to me. And you notarize, that thing is notarized. You're attesting that you're the person that should be getting it. Now, if you don't have a will, then you have to demonstrate that there's an intestate succession that should go to you. And if you're a son or a daughter of the decedent and you can show that, that's fairly simple. The problem comes into if you have estates larger than that, gross estates larger than 166,000, and anytime you have a house in California, you've got you've definitely got that. Then you can't just do that. You have to go through the probate process, seek out letters of administration, and a process of notifying anybody who could be a creditor to the decedent, anybody that the decedent may have owed money to, because they get the first kick at that estate. So now other states, and I can't speak for them, but that threshold is much lower in other states.
Oh, okay. So now when you say the amount of the gross estate, that's the total value of assets minus liabilities, is that correct? Or just
No, it's gross.
Okay, so it's before the liabilities are subtracted.
Exactly. Yep.
And does that include the value of any life insurance policy?
Well, so there's a couple of things here to think about. There's what's the gross estate for probate, and what's the gross estate for estate tax.
Okay.
So for the IRS, the gross estate for the IRS, what they count for estate tax planning, they count all that, your 401ks, all your IRAs, life insurance, the value of any property, all that counts towards the gross estate for estate tax.
Gotcha. Okay.
Probate, to get through probate, most of that stuff passes outside of probate and doesn't count towards a gross estate for probate.
Oh, okay.
So kind of two different things. And when you talk about estate tax and IRS, then they throw all that in, life insurance, everything. You got to be so, and there's techniques to make sure that your life insurance does not get counted towards your estate. Now, remember, the estate tax exclusion amount right now is really high. There's not that many people that pay estate tax. Estate tax exclusion individual is over $6 million. So you got to be fairly wealthy. And if you're a couple, if you're married, there's the lifetime, what's it called? The spousal exclusion. So anything, if you die, if you're decedent, anything that your wife or husband, or your surviving spouse inherits from you, there's a unlimited exclusion. They don't have to pay estate tax. So you can bequeath $12 million if you want to your spouse when you pass, because IRS knows, well, the surviving spouse is going to die pretty soon too. Then we'll take our cut. Right. So there's techniques to use all that exclusion across the two spouses, so you limit the estate tax as much as you possibly can.
I did a show on this in the last couple of weeks. I believe in a couple of years, the exclusion amount is going to drop. That I don't remember. I don't recall now what the lower amount was, but my understanding is that's going to change. Have you heard anything about Congress potentially extending the higher exclusion? Is that being talked about in legal circles these days?
Well, I think it's December 31st, 2025. I believe is the date.
Yeah.
Or you could actually count the number of days to it will go down to, I believe it's 3.5 million is the exclusion amount. That will put a lot of people in California into a state tax planning problem. I doubt, given our current political situation, I'll find it very hard to believe that our Congress can actually do something and actually agree on. They've been talking, not saying bad about anybody or any political party. It's just the current situation happened because of it was a anomaly that they got that through at the time, and it's set, and it's only, and lawyers that got through because it was set to expire and go back in 2025. I doubt very much that Congress will change that. We talked about that. There was actually some talk when the Biden administration started that, and the Democrats controlled both houses, that it was going to shrink. They were going to bring that back down. Bernie Sanders and some others had some proposals to do that, to eliminate a lot of that exclusion. But it was just so painful. It's so politically painful for those people to put through that it never. And so I think it will expire. I think it will expire on 2025. And people, I mean, me, I need to start thinking about that. Like $3.5 million can, if you're in California, you live in a residential property in anywhere in LA County, San Diego County, anywhere in those counties, and say you decide to put an ADU, or auxiliary dwelling unit, or you have one rental property or something, you're very likely into that estate tax exclusion amount, and you're going to have to figure out what to do to get it to as much as you can to avoid estate tax is really, I think it's 37%.
Right. I think
that's pretty high.
And plus, well, is there a state estate tax as well?
It depends on the state. I don't. So we have to worry about this so little because it's so high. I don't think California has an estate tax. That probably will change.
Right. So, so there's two different issues that we're kind of tracking here. One is the size of your estate with respect to probate and how to deal with that. The other is the size of your estate with respect to taxation, which is kind of on a track that's going to take a big turn in about a year and a half. So as you work with your clients, how do you deal with that uncertainty on the tax, on the estate tax issue, especially for someone who maybe is very elderly and they may die, let's say, in the next year, but and so it may make sense for them to act as if they're going to get the larger exemption, and yet if they live kind of 18 months plus 1 day, the whole regime is going to change, and you can't redo an estate plan on a dime, right? So how are you dealing with that particular issue?
Well, so much of estate planning, the process or the basic thought goes back way back a long time ago, from 90s, 80s, long time ago. And in those years, the estate tax exclusion amount was like $500,000 in the 90s. So everybody was dealing with this problem. And so the idea was, and what developed out of that is, what you hear is AB trusts, marital trusts, marital shares, non-marital shares. And what we try to do is, so when a state, so you have an estate, a married couple together, say they have a $12 million or together. When that first, and in California, it's all community property possibly, but when that first spouse dies, and you end up with two separate shares. You have a deceased spouse share and the surviving spouse's share. And you always think about those things. So what you do is you take that deceased, you use all of the exclusion amount of the deceased spouse, much as you need anyway, and you put that in a share called a non-marital share. That's the deceased spouse's share if it's the deceased spouse's exclusion amount.
Mhm.
And then you put the other part into what's called a marital share, and that gets counted towards the surviving spouse's estate.
Oh, okay.
Okay. So when the surviving spouse passes, the surviving spouse's half of the community property and this marital share all get counted against the surviving spouse's estate. That makes sense. It's hard.
Mhm.
It's three different parts that you combine together.
Mhm.
Well, so the challenge is to take, so you have put enough into the non-marital, the deceased spouse's share, so
Mhm.
the deceased spouse doesn't pay estate tax. And then you want to have, but then you put this other chunk into the marital share and the surviving spouse. So when the surviving spouse passes away, you don't want the surviving spouse to have to pay estate tax either. When I say she, because the fact of the matter is most of the time the guys we we die before our spouses most of the time. So I say she, the surviving spouse. Okay, it might be the guy, but anyway, when she passes, um, you don't want her to pay estate tax either. So then what you do, there's a portability. So there's a portability of the exclusion. So if you don't use all of the deceased spouse's estate tax exclusion, that can be ported to the surviving spouse.
Oh, okay.
So the surviving spouse, there may be right now it's $6 million, but if you only used, if the deceased spouse only used $3 million, and you put $3 million, so he's got there's $3 million of exclusion still.
Mhm.
You port that, get your CPA to do the right forms to qualify for that. And then the surviving spouse, so now the surviving spouse's estate can be up to $9 million because you ported $3 million and she had $6 million. So now she can die with an estate of as big as $9 million without paying estate tax. So those are the kind of planning factors you come into. So
Gotcha.
it's those shares and the portability and the lifetime exclusion amount, spousal inheritance that each spouse can have. So which you play with all those things. Now in California, so that's just, so you've got that. That's estate tax.
Mhm.
You've got the other problem you have is, so capital gains tax. You got to think about that too,
Mhm.
because as a married couple, there's a $500,000 exclusion, and really this is CPA world. You need to get CPA in here, but there's a lifetime. There's a $500,000 exclusion for capital gains. So as a married couple, 250 is a single. So if you buy a house and it grows and you keep it for 15 years, it's going to grow. It's going to appreciate in California. Now, there are places and things where it depreciates. That does happen, but
Does.
most of the time in California, it'll appreciate.
Right.
And 15 years, it'll appreciate probably. If you're single, it'll probably appreciate 250, and if you're married, I mean, it's going to appreciate them.
Right.
And
Yeah.
so when you sell it, you got to pay the capital gains tax on anything over that exclusion amount. So you got to think about that too. When you die, there is a step up in basis to the date of your death. You got to remember that too. So you get that. So your heirs do not have to pay that capital gains on that. Now, there's a community property aspect of that too, because the way it's titled. So you got to think about that. So you got capital gains. You got a state tax to worry about. Your last income tax you got to think through that last year. And then last thing in California is the property tax and how that passes and and when does that property get reassessed?
Mm.
Because you got to be really careful about that too, because California is trying. Now there are lots of exclusion, but that Proposition 13 has been just amazing for homeowners who can grow their estates and the value of their home over time without constantly getting a tax increase. A lot of people don't like that and think that they should. And it helps, pays their schools and stuff like that. I'm not getting into that, but the point is, you've got to be really careful that that's the other thing. You got to think about the reassessment for property tax. And a lot of people in California, what they would do, they built estates by passing their property, real property, to family members, to their sons and daughters, and sons and daughters, inherited these properties for years. Well, Prop 19 really put a limit to that. Now really put a kibosh on a lot of that. So, but you have to think. So when you do estate planning, you got to be thinking about all that stuff.
Mm-hmm.
And then, so that's part of it. But then you've also got to think about disability. What happens, when you start, as you get older, you get dementia, Parkinson's, things like that. We all hope that doesn't happen, but we don't know. That's the thing. That how do you want? You've got to be. So the trust and the will and all that stuff takes control when you pass, when you die. Mm-hmm. What happens if you don't die and you can't start making decisions about how do you keep things going? I mean, you've got a house, you got to have it repaired. There's leaky roofs. There's, you have income tax to pay. Who's going to pay? Who's going to do your income? Well, that's all disability planning. Who's going to tell the doctors whether you should have surgery or not when you're, struggling with one thing or another? Right. Who's going to be there to make sure you take the medicines that you need to take when you're not with it anymore? And that's a very big part of estate planning as well. And that's the power of attorney. In the Marine Corps, as a young person, we used to make Marines do a power of attorney on their first deployment, a will and a power of attorney. Well, two things. Will, if they pass, because Marines, you do dangerous stuff and lots of weird places in the world and lots of very complex equipment, and stuff goes wrong. So you have a will that makes sure that whatever it is you have passes easily to mom and dad if you're not married, or if you're married, to your wife. Well, what happens if you're not dead and they can't find you, or you're missing in action, or prisoner of war or something like that? Who's going to keep your stuff going? Well, we don't have a death certificate. You're not dead, but you can't do anything. You're incapacitated. Well, all that stuff can happen to any of us at any
right.
Go travel worldwide or something like that. Something bad can happen, and that's the power of attorney there. Named, but you've got to name somebody, and you need to think about this. People, who are you going to name? And that's, people struggle. One, they struggle with thinking about those two things: their death or their incapacity. People don't like to think about that at all. They struggle with that. And then when they kind of come to grips with, hey, I do need to think about that because I got stuff and I have loved ones, and I want to make sure my stuff goes to those loved ones easily. the next question is, who do I trust to make sure my stuff, after I'm gone, my stuff goes to the people I wanted to in the way I wanted to? And that's a lot of people struggle with that. It's hard to, wow, if I was gone, who would I trust to make sure? And and a lot of people, if they're married, hopefully they're comfortable with their spouse. But if you and they name their spouse, well, what if you and your spouse are on the same airplane that goes down, or you and your spouse are in the same car crash? Who's next? That's the challenge. Who's next after that?
Well, gosh, this was the fastest 30 minutes. Actually, we've gone overtime, as a matter of fact, for the show, but I wanted to let you keep going with your explanation, because everything that you were saying was so good, and it's so important for people to understand this. So, but unfortunately, we're going to have to wrap up here. So I just want to thank you, Paul, for coming on the show and sharing your thoughts. We're going to have you come back. There's obviously much more we can talk about on these subjects. I've got a half a dozen questions stacked up. So we'll definitely have you back. But thank you very, very much for coming on and sharing your expertise with us.
Thank you, Kevin. I really appreciate it.
So before I sign off, just want to remind you again, we're here with Trust and Estates Weekly every Monday, 10 a.m. Pacific time. Tomorrow is my show, Business Lessons from the Military. My guest is Captain Mark Brooker, United States Navy retired. He's an expert on leadership and also a published author. So I invite you to join us tomorrow at 11 a.m. Pacific time, 2 p.m. Eastern time for Business Lessons from the Military. And then on Wednesday is my show, People Making Money. And that is at 12:30 p.m. Pacific, 3:30 p.m. Eastern time. And my guest on People Making Money is Lori Israel. She's a lawyer who has specialized in family law for her whole career. And she's going to be talking about another very difficult subject, which is marriage and money. not necessarily the part for what happens when you're dead, but how you handle that whole situation. Lori has been a mediator. She's worked with prenuptial agreements, etc. So I invite you to tune in all week long. And then, of course, next week, we're going to do it again. I'm going to have some special shows for the week of 4th of July. So thank you all very much for joining me. Again, Paul Hilton, thank you so much for coming on the show today. And I just want to wrap up, as I always do, by mentioning my dear, dear friend who has passed on, Marie. Darling, you are and ever will be my Belle. Thank you so much, folks. All the best.